The Department of Justice, DOJ, filed the respondent's case in the Foreign Domestic Helpers, if I may use the term, FDH, right of abode appeal in accordance with the Court of Final Appeals appeal procedures yesterday afternoon. As the respondent's case is a court document, and as the hearing of the case has yet to begin, DOJ did not disclose the document or its contents. There are, however, news report today suggesting that DOJ would make use of the FDH case to ask the CFA to seek an interpretation from the Standing Committee of the National People's Congress, NPCSC, pursuant to Article 15H3 of the Basic Law, in order to clarify the legal effect of the NPCSC's interpretation made in 1999, and to resolve the problems created by babies born in Hong Kong to mainland couples who have no resident status in Hong Kong, the so-called mainland pregnant woman problem. As the government's argument in the FDH case have been disclosed by third parties, and as an academic has warned that the turbulent storm of our legal system, which Mr. Justice Bokhari, MPJ, is wary of, is approaching, I would like to make a few remarks. Firstly, since judicial process of the FDH case is ongoing, DOJ has not disclosed its arguments or strategies in that case. This is consistent with the department's usual practice and legal procedures. DOJ also does not wish to unduly affect judicial independence by such disclosure. Secondly, DOJ invites the CFA to consider seeking the NPCSC's interpretation under BL 15H3 to clarify the legal effect of the 1999 interpretation, because this is a relevant issue which needs to be resolved in the present case. The penultimate paragraph of the 1999 interpretation stated that the legislative intent of all categories of Basic Law 24(2) has been reflected in the opinions on implementation of Article 24(2) of the Basic Law of the Hong Kong SAR of the PRC, adopted by the Preparatory Committee of the Hong Kong SAR in 1996. The legal status of the 1999 interpretation and the 1996 opinions of the Preparatory Committee and the binding effect, therefore, involve complex legal issues. If such issues can be clarified, DOJ considers that the clarification can facilitate a proper interpretation of the right of abode for all categories of persons under Basic Law Article 24(2), including the FDH. Thirdly, this is not a case where the government requests the NPCSC for an interpretation. Instead, the government, under the Hong Kong judicial system, requests, in accordance with Basic Law 15H3, the Court of Final Appeal to consider whether to refer to the NPCSC the legal issues on the 1999 interpretation for clarifications. Most importantly, whether to refer to the NPCSC for an interpretation is a decision to be made by the CFA in accordance with our common law. Therefore, there can hardly be any damage to the rule of law or jeopardizing of our judicial independence. It is exactly because of the consideration of judicial independence that the DOJ had not publicized the way in which the FDH case is being handled. This government absolutely respects the rule of law and judicial independence. We will adopt the same cautious attitude in handling the FDH case and the mainland pregnant woman problem. Therefore, I do not agree that DOJ's handling of the FDH case would bring on turbulent storm to the rule of law of Hong Kong. Finally, I would reiterate that the request by the DOJ for the CFA to consider referring to the NPCSC for clarifying the effect of the 1999 interpretation under Basic Law 15H3 would absolutely not affect the rule of law and judicial independence of Hong Kong. On the contrary, this measure will hopefully assist to resolve the right of abode issue of different categories of persons including foreign domestic helpers and babies born to mainland pregnant women. This is also consistent with the idea that I have emphasized in the past, that is, to resolve the relevant issue under the legal system of Hong Kong.